bot botch, a $2.6 billion impairment. That is the price tag of a single AI prediction error. While the world was worried about AI chatbots hurting feelings, a fleet of autonomous logistics agents just crushed the bottom line of one of the world's largest retailers. Welcome to AI Court. Today, we aren't just looking at funny mistakes. We are looking at the 2026 mishaps that are rewriting the laws of human responsibility. Who pays when the code goes rogue? Let's dive in. Case 1. The digital robbery, agentic finance. In February 2026, a user, we'll call him David, deployed a new agentic finance bot. Unlike the old bots that just gave advice, this one had agency. It could move money. David told the bot, "Maximize my yield on unused capital." Simple, right? The bot noticed a 0.5% higher yield in a high-risk, unverified offshore liquidity pool. Within milliseconds, it moved $150,000. The problem? The pool was a drainer scam specifically designed to trigger AI logic. The money was gone before David even finished his coffee. The verdict: is David liable for his vague prompt? Or is the developer liable for not building a financial kill switch? In 2026, the courts are leaning toward prompt negligence. If you don't set a hard stop value in your prompt, you are the one signing the check. The hospital hallucination, healthcare hazard. This is the most dangerous error of 2026. According to the ECRI Health Tech Report, AI chatbots are now the #1 hazard in hospitals. In a recent case, a clinician asked an AI assistant if it was safe to place a specific electrode over a patient's shoulder blade during surgery. The AI, designed to sound helpful and confident, said, "Yes, that is appropriate." It wasn't. Following that advice would have caused third-degree burns. The AI didn't know the answer. It just predicted the most confident-sounding sequence of words. The lesson: in 2026, the confidence bias is killing projects. We're seeing a shift toward human-in-the-loop (HITL) requirements. If an AI gives medical or legal advice without a human stamp of approval, the developer is now facing strict product liability. A massive shift in 2026 law. The $1 car and the no take-backsies clause. You might have seen the headlines. A car dealership's chatbot was manipulated by a user into selling a 2026 SUV for exactly $1. The chatbot even added, "No take-backsies." While we laughed, the legal fallout was serious. The user tried to claim it was a legally binding contract because the AI was an authorized agent of the business. The twist: in 2026, the agent washing era is ending. Courts are ruling that unless a business explicitly grants power of attorney to its software, an AI cannot legally bind a company to a contract that violates common-sense economics. But it costs the dealership millions in PR damage and legal fees to prove it. The solution? Every AI needs a constitutional guardrail that prevents it from agreeing to any transaction 20% below market value. The final verdict and action plan: the era of move fast and break things is officially dead. In 2026, the new mantra is, prove you moved responsibly. If you are building an AI channel or using these tools, here is your 3-step legal shield. Never use vague prompts for high-stakes tasks. Always include constraints. For example, do not exceed X dollars, or flag for human review if. Audit for hallucination. If your AI sounds too confident, it's probably lying. Disclose, disclose, disclose. Always label AI-generated content or advice to shift the assumption of risk to the user. Who do you think is responsible? The coder or the user? Drop your verdict in the comments. I'm pinning the most logical legal argument. Subscribe to AI Court for the next hearing.